Good morning, good afternoon. Thanks everyone for joining us. My name is Marcy Koski. I am a partner at Husch Blackwell in our Madison office. It is a cold and gray day out, but at least it's Friday. I also lead our firm's consumer financial services practice, national practice, which is across the firm's footprint and by our link office across the country. I help consumer finance companies and financial institutions with the complexities of compliance, as well as advise on various litigation issues. Before we begin today, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, which we hope to get to all of them, but if we don't, we will follow up with you thereafter. Please submit via the question box. A PDF of the presentation is also available in the program materials folder. This program has been approved for legal education hours. For live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. All right, that's all for housekeeping items. Let's get started with our great program. Joining me today are two members of our consumer financial services team, Mike G. Silver and Chris Friedman. Sorry, Chris, but the star of our show today will really be Mike, who until February 2024 was at the CFPB since basically its creation. While he was at the CFPB, he played a central role in writing some of the agency's most impactful rules and guidance. Mike uses that experience to advise the firm's consumer financial services and fintech clients on regulatory compliance matters. One particular shout out to Mike is that he helped write the payday lending rule, which we will talk a little bit about today. And in terms of looking at what has happened in the past and what might happen in the future with a new administration. Mike's practice draws on his broad portfolio of CFPB work, including issues relating to UDAP, mortgage origination, consumer lending, regulations involving innovation, technology, and digital marketing tools, small dollar lending, deposits, and debt collection. As I mentioned, Mike started at the CFPB just a mere 6 weeks after its founding in 2011 and left earlier this year, so he knows the agency inside and out, and specifically has worked under 6 agency directors and 3 different presidents, giving him unique perspective on the coming transition. And in fact, I think he might be the only person in the marketplace on the private practice side who could probably claim that right now. Chris, Chris is also a partner on our consumer financial services team. He is focused on providing business-centered legal strategies to financial services companies designed to manage risk. Bringing a deep and broad experience in the financial services industry, Chris advises consumer lenders, fintechs, buy now, pay later companies, banks, credit unions, mortgage companies, and service providers about regulatory and compliance issues. With that, I will turn it over to Mike. Oh, Mike, I'm sure you're saying great things, but you're on mute. All right, well, while Mike figures that out, I'm gonna dive in and I'll tell you what is the roadmap today. So first, we're going to dive into the CFPB leadership transition. We'll touch on the Congressional Review Act, which, as a little teaser, might impact the choices that could be made as to how to maybe pull back some of what Chopra has done. The rulemaking agenda, what rules we think are on the chopping block. Guidance, are we going to say goodbye to circulars, which were a new thing to the CFPB under Rohit Chopra? And are we going to say hello to a revitalized innovation office? Finally, we'll talk about the impacts to supervision and enforcement. And if we have time, we'll discuss some other implications. Mike, are you all set up now? Nope.
Mike, are you still muted?
Mike, all right, he's going to log in and log out and log back in, but we will continue along. I actually think we should probably, because Mike's insight into these particular slides are so important. Are you good?
Do you hear me now?
We can hear you now. All right.
All right. Sorry. I don't know what's going on with the audio here from the basement in Bethesda, Maryland. Thank you, Marcy and Chris. Appreciate the introduction. There's a lot to talk about, and I think part of the exercise here is to try to demystify the whole process of a transition at the CFPB. And this is, the CFPB is such a unique agency in the federal government because it's so young. It's only 13 years old, just like my older daughter is soon to be. It's gone through, a handful of transitions, which I lived through at the agency. But because of creatures of the Dodd-Frank Act, Supreme Court cases, and just the general tenor of the agency, it's just not a traditional transition in the sense of other executive and independent agencies that people prepare for. So we're going to just talk through the agenda, talk about potential who might be the next director, but also really talk about the process of how change is effectuated at the CFPB as a particular institution. And that's what I'm hoping really could be the insightful takeaway here during this webinar. So to first talk about the leadership transition. So on January 20th, Inauguration Day, Director Chopra will be serving at the pleasure of President Donald Trump. And unlike in 2017, when then Director Richard Cordray remained on the job for about 10 months into the Trump administration, Chopra will be asked to resign or be fired if he doesn't do it voluntarily. And this is because of a change in the law implemented as a result of the Supreme Court decision in 2020 in the Celia Law case. And this was a case about separation of powers and the structure of the CFPB under the Dodd-Frank Act. And essentially, the issue was whether the president has the ability to terminate the CFPB director for cause or for any reason or no reason at will. And as the statute originally was structured, the CFPB director and the removal clause in the Dodd-Frank Act only allowed the president to terminate the CFPB director for cause. And this is similar to removal provisions in a number of other, related to a number of other independent regulatory agencies. And there were a number of legal challenges over the years, which ended up resulting in a case that went up to the Supreme Court, and they held 5-4 that the Dodd-Frank structure at the time was unconstitutional because it didn't allow the president to hold the CFPB director properly accountable. So they made a change. They didn't, revoke Title 10 of the Dodd-Frank Act. They made a very targeted remedy, which was to essentially change the removal provision to allow the president to fire the CFPB director for any reason or no reason. So Kathy Kraninger, who was the CFPB director under the Trump administration, she resigned the day of the inauguration for President Biden. And so this will be the same thing that happens to Chopra. And additionally, Chopra has a number of senior executives and advisors who were hired either as political appointees or under somewhat murkier status in terms of whether they're considered career staff or political appointees. But a number of the top executive roles at the CFPB, such as the general counsel, the head of enforcement, the head of supervision, and many of his influential advisors in the director's office, they all will be potentially let go or would follow suit as well. So there really is going to be a big change in terms of leadership. Again, not just the director himself, but also his core group of advisors and senior executives.
Mike, can I just interject and ask a question, or maybe make a comment and ask a question? In preparing for today, we were discussing actually just this morning how in Celia law, right, it started before Trump was elected. And so there was a particular position taken by the government as to whether the directorship was constitutional. And then when Trump became president in 2017, there was a flip, right?
Yeah, that's correct. The first federal appellate court decision that held under this theory that the CFPB was unconstitutional was actually in the DC Circuit Court of Appeals, when now Supreme Court Justice Brett Kavanaugh was on the DC Circuit, and he wrote the opinion in a 3-judge panel, I believe in 2016, in a case called PHH that involved rest of Section 8, but it ended up turning into a constitutional challenge. And Justice Kavanaugh was really the first one to, at that level, hold the CFPB to be unconstitutional under this theory that it was a violation of separation of powers. What was interesting, and to your point, Marcy, it's an excellent point to raise here, is that for many years, the CFPB was warding off various legal challenges on this same theory, including in the DC Circuit, where they successfully petitioned the entire DC Circuit to rehear the case en banc. And then in 2017, the full DC Circuit reversed the 3-judge panel with Kavanaugh and found the agency to be constitutional. And that was also, I believe, the result in the 9th Circuit when there was a case that went up there. But eventually, that same theory about separation of powers ended up getting traction in the Supreme Court, and it was a 5-4 decision. So, and to your point, once the Trump administration appointed leadership came into power, they, along with the Solicitor General's office, the DOJ, decided to take a different position once that issue went up to the Supreme Court. And I believe my recollection is that the Supreme Court actually requested an intervener, or basically, I think Paul Clement was asked to argue the position that the CFPB had previously taken, that it was constitutional, in order to hear that argument as part of the Celia law case.
And I think that's just a material point to make here when we're talking today about ways that the CFPB, positions that the CFPB has taken may change. So just a little bit of a preview there. So.
Yeah, no, definitely. We'll get into some of that in terms of the rulemakings and what might be on the chopping block. So in terms of the actual transition and who might be coming on board as the CFPB director, just as a brief recap of the structure. So the CFPB director is a Senate confirmed or Senate confirmable position. So President Trump or President-elect Trump has not yet nominated a CFPB director who would go through the advice and consent of the Senate. That presumably would be expected to happen in the next several weeks after the announcement of nominees for, say, the Secretary of Treasury and the other executive agencies. It's undoubtable that the nominee will be more industry friendly. And I think that's probably like the most obvious point that anybody will be making during this webinar. I think the wrinkle that I would characterize it is the new person going to approach the agency as if they want to break things and not really respect the legitimacy of the agency and treat treat it as if it's a lot of the criticism from Republicans in Congress and conservatives over the years, and treat that as legitimate, or are they going to approach it from more of an incremental perspective to try to fix it? So are they going to break it or try to fix it? And you know, we'll cover this in the next slide, but I think two of the directors under the prior Trump administration, I think, offer contrasts in that approach, and I think that's a good analog. But an important point here to emphasize, and this gets pretty technical, and I'll try to summarize it at a high level, but the CFPB doesn't really have a succession plan for what happens if the director leaves or is fired. And you know, the most obvious outcome would be that the deputy director would ascend to become the acting director, but that is not going to happen because the deputy director, Zixta Martinez, has been at the CFPB since the very beginning, and so she would not be palatable as in that position to the Trump administration. So then you have to look to the Federal Vacancies Act, which gets into the qualifications and criteria for who could take over temporarily to lead an independent or executive agency. And there's some you know, very specific criteria in terms of you know, who would be eligible to serve. And to distill it, it really has to be somebody that's been in government for a certain period of time and is at a high enough executive level, you know, either someone who's already a commissioner of another agency or cabinet level or one or two levels below that. And there's really nobody at the CFPB right now who is at a high enough executive level who was hired by the Trump administration who would potentially be palatable to you know, the incoming Trump administration. So there's been a lot of speculation in DC about, well, maybe they'll bring somebody part-time from the FTC or the FDIC or the Commodity Futures Trading Commission. There are certain independent agencies where there's a commission or board structure, and there always have to be a number of Republican and Democrats on the board at the same time. Those are really the only examples where there's currently a Republican serving in the Biden administration in a high enough executive level to be considered for that acting director role at the CFPB. And again, this is a nuance that reflects the unique situation that this is the first time that we're going through a transition from a Democratic to a Republican administration after Celia Law, when there's going to be an immediate transition. Last time, again, Richard Cordray stayed on for 10 months. By that point, President Trump had gotten all of his cabinet picks approved. There were plenty of people in the government that were eligible to serve. That's not going to be the case this time. And so I want to talk a little bit about kind of what it was like at the agency, living through and working through these various transitions, and what lessons that might be gleaned from those prior transitions, and to really kind of offer a little bit of color on what happened, what that might presage going forward. And then, as Marcy indicated, we'll get into more of the brass tacks about what is on the agenda currently, what might happen with those various items, what might happen with supervision and enforcement, et cetera. So again, as I was alluding to a few minutes ago, we've had transitions now from Rich Cordray, who was appointed by President Obama, to Mick Mulvaney, who, if you recall, was a congressman from South Carolina, who became the director of the Office of Management and Budget under President Trump's first term. He was asked to be the acting director of the CFPB as a part-time side hustle, essentially, while he was running the OMB. And then Kathy Kraniger was nominated and approved by the Senate, and she started her term, I believe, towards the end of 2018. So there was a transition from Cordray to Mulvaney Kraniger. Then there was the transition from Kraniger to a guy named Dave Waggio, who was a management in the CFPB for many years, and he took on the acting director role. And then Rohit Chopra, who had been an FTC commissioner under the Trump administration, he was nominated and confirmed by the Senate. So there's a very strange, bizarre example of the CFPB uniqueness that and sort of in the lore of the CFPB's history, which was in 2017. It was around Thanksgiving when Rich Cordray decided to resign because he ran for governor of Ohio. There was a brief moment in history when the CFPB had two different people claiming to be the director of the agency, because Cordray, on his last day, I think it was a Friday, he engineered what he thought was a succession plan where he promoted his then chief of staff, a woman named Leandra English, to be the deputy director of the agency. And then he resigned so that she would then, as the deputy director, become the acting director. But at the same time, or later that day, President Trump now announced that Mick Mulvaney would be the acting director. So there was I remember seeing MSNBC was reporting about this, and there's all this drama over that weekend, and there were legal filings. There ended up being a lawsuit in the District Court of D.C. And on that Monday, Mulvaney showed up to the office, and there was press on this, where he brought a very large box of donuts, and he opened his office and sort of had office hours, and was saying, "Well, I'm here. I'm the acting director. Here's donuts for everyone." While Leandra kind of took up, residence at the second CFPB building, and was sort of also claiming to be the acting director. So very bizarre situation. It was quickly resolved when the legal division of the CFPB took the position that Mulvaney was the rightfully appointed acting director. Now,
Hey, Mike, how impactful were the donuts? Were they good donuts? Like,
I don't think I got one.
What was that?
I don't think I got one.
Oh, did they run out or?
Yeah, they must have run out. I think they were Krispy Kreme, and I'm much more of a Dunkin' fan than Krispy Kreme anyway. But maybe we could argue about that separately. But in any event, so that again, that is something that, again, academic point, lore of the CFPB, that will not happen now because we're post-Celia law, and any type of clever succession plan would get instantly rejected because the deputy director could then just be fired by the president, just like the director could be fired by the president. But shifting to kind of more serious terrain, I would say that there are a few recurring themes that we can draw on here to kind of predict what might be, foreshadowing what will happen. So one is that you're going to see shifts of tool choice, and this is something that was, you all are on the receiving end of this as industry participants, and it's very clear, kind of looking back and reflecting on the various regimes, that Director Cordray was a big fan of enforcement. That's when the whole regulation by enforcement tag came about. Whereas Director Kraninger was more bullish on supervision. She prioritized supervision. She had a notion of prevention of harm as a way of trying to get at problems before they metastasize, so that it never gets to enforcement. You kind of deal with it in a lighter touch way. And she also really was a firm believer in the innovation program, which we'll talk about later. Chopra, of course, has gone in the direction of maybe moving away from formal rulemaking and moving much more towards non-rulemaking guidance. So this is, I think, something to keep an eye on, and there definitely will be a shift in tool choice that I would predict going forward. The second, and this is really a perennial topic of debate, and I think it's a healthy difference of philosophy between progressive, conservative, Republican, Democratic administrations, and that's what is the role of a consumer choice and more of a disclosure-based approach to consumer regulation versus a more substantive and some would argue paternalistic approach. And then I think as a corollary to that, do they write rules or guidance in a more principles-oriented way, or do they take an approach that's more prescriptive? And there's always trade-offs. And prescriptiveness means more certainty, but it also might mean more onerous requirements and more expensive requirements. And then lastly, and this is something if you've watched prior webinars that we've done on the CFPB or seen anything I've written publicly, the continued maturation of the agency is really a key question here. I made the reference earlier to my daughter being almost 13, and the fact that the agency is still so young compared to other agencies that are over 200 years old. They haven't developed the institutional norms and processes and guardrails yet to really have a solidified structure. And whether new leadership decides to kind of continue really just focusing on the policy outcomes and less on institution building, or maybe reinvigorating that is a question. And then lastly, I think, and Chris always makes the, like is fond of the phrase, judges are unpredictable, and I would broaden that here to say, events are unpredictable, particularly related to the CFPB. So really, I would say expect the unexpected. And just a few, concrete examples. Kathy Kraniger was not on anyone's short list to be nominated to be the CFPB director in 2017. All of the sort of in the know, trade press, all the names that were floated, she emerged as the nominee almost by total surprise. And then she also governed in ways that I think maybe weren't as predictable as one might expect, given that she was appointed by President Trump. For example, she made a really favorable agreement with the employees union in 2020. Frankly, more favorable than the agreements made under Democratic appointed administrations. And we'll talk about this more, but Marcy mentioned the payday rule that I worked on for 5 years. One would have expected, I think we probably even expected at the time when I was there, that the new administration would come in, and then the whole thing would be scrapped. And as it turned out, the approach they took was much more surgical. Both Mulvaney and Kraniger had the opportunity to revoke the entirety of the rule, and they both chose not to. They just revoked the ability to repay requirement. Now, to be fair, that was the much more impactful piece of the rule, but there is a residual part related to payment authorization and the number of representments. And both of them decided that they felt that was reasonable policy, and they defended that position. And to this day, it's still tied up in litigation in the Fifth Circuit, but there's a very good chance that that piece of the rule will survive 12 plus years later. And that's because both Democratic and Republican administrations allowed for that part of the rule to go forward. So again, politics, policies, political alliances, these things are not always the stereotypical way. And I think Chris and Marcy will talk about some of this later in terms of the specific rules and what might happen. So we do have a poll question here because there's, I think, one state where there are some CLA requirements. So question is, and hope Celia will let me know if I'm doing this right, who do you think is going to be the next CFPB director? Is it going to be Brian Johnson, Ed Heiser, David Wooderson, Todd Zawicki, or Bill Lumberg? And certainly if it's Bill Lumberg, it's going to be a much more bureaucratic place than it already is, with lots of TPS reports. Please submit your responses. All right, I think we have critical mass of responses. So I'm going to move on to Brian Johnson and Todd Zawicki, not surprisingly. Wow, 11.6% voted for Bill Lumberg. Man, that's going to be a pretty dry and boring place, especially on Friday evenings. So let's talk about the Congressional Review Act. This is a wild card, and Marcy is going to take this away.
All right, thanks, Mike. You forgot to say that Ed Heiser got 16% there. And for those of you on the phone who know Ed Heiser, that's awesome. All right, so let's talk about the Congressional Review Act. The Congressional Review Act is a tool that Congress can use to overturn certain federal agency actions. The act was codified in 1996. Its first use was in 2001, and then its subsequent uses were from 2017, largely in the Trump administration. I think I counted that there were 17 uses of the CRA. And I don't know, Mike or Chris, one of you, I think you might need to mute. I hear some background noise. CRA was used 17 times during the Trump administration and 3 times during President Biden's administration. Let's delve a little bit more into the Congressional Review Act before we think about how it could be used during the second Trump administration. So the definition of rule under the Congressional Review Act is different from what you would think of under the APA. So it's very broad. It means the whole or part of an agency statement of general or particular applicability and future effect designed to implement, interpret, or prescribe law or policy. And why does it matter that the CRA definition of rule is very broad? Because by being so broad, it can pull in not only legislative rules that have been promulgated by an agency, but also non-rulemaking guidance that would typically not be subject to notice and comment rulemaking, of which there has been a plethora from under Rohit Chopra. So when it is a legislative rule, typically what would happen is the CRA requires agencies to submit that rule to Congress and GAO. They're typically submitted around the time that they're published on the Federal Register, and then the Congress has 60 days to act to pass a joint resolution. But that 60 days is calculated based on 60 days of a continuous session period, beginning when the rule is published in the Federal Register and received by Congress. So the thrust is that under the Congressional Review Act, it could be an APA rule that is considered within that 60 days, or a non-rulemaking guidance that falls within this broad definition of the CRA of the Act. All right, moving to the next slide. We have a little bit of history to guide us here. So as it pertains to consumer finance. So in 2017, as many on this call might remember, the arbitration rule was CRA. So the arbitration rule was an APA rule, and it fell within that 60 days of a continuous session. So Congress was able to pass a joint resolution, which was ultimately signed by President Trump. As noted, there's also the ability to look at non-rulemaking guidance and apply the Congressional Review Act to non-rulemaking guidance. We also have some history for that in the consumer finance space. As some on this call will remember, in May of 2018, the indirect auto lending and compliance with a COA bulletin, the CFPB bulletin, was overturned. As a reminder, that bulletin signaled the Bureau's intention to hold downstream finance companies responsible for purported fair lending violations that occurred when dealers marked up the APR from the buy rate from the finance company. So for that kind of non-rulemaking guidance, the 60 days starts when a member of Congress may request that the GAO give an opinion as to whether that non-rulemaking guidance falls within the definition of a rule under the CRA. And if the GAO issues an opinion that says, yes, indeed, that is a rule under the CRA, then the 60 days begins at that point. And Congress has 60 days to pass a joint resolution and have it signed by the president. The impact of CRAing a rule is significant. It means that a rule may not be issued in substantially the same form, and it cannot be substantially the same unless specifically authorized by a law enacted after joint resolution. So even though we're heading into an administration that very well could revoke certain non-rulemaking guidance that has been published or issued, if instead there's a path where non-rulemaking guidance is CRA, that impacts what a future agency, perhaps a less friendly future agency, may do with respect to that prior non-rulemaking guidance. So it's a really, potentially a very strong tool that could be used in the coming months to affect what a future CFPB under a different administration could do. In fact, so that non-rulemaking guidance, but of course rules that have been proposed within the 60 days of continuous guidance or continuous session. Some of you may have seen that yesterday, the larger participant rule regarding big tech came out. And Mike, I don't know if you have any thoughts about that. Oh, Mike is on mute again. Mike's having. All right, well, so as some of you saw, the larger participant rule regarding big tech came out yesterday, and from what we've heard through outreach to those in the know in DC, the CFPB does seem to be moving full steam ahead and intends to release everything slated to be released and seem to be taking their chances with the CRA. And the larger participant rule regarding the big tech certainly seems to support that. Mike, are you back?
Hi, you hear me now?
I can hear you now, yep.
Okay, not sure what's happened with the mics, but yes. Yeah, and Marcy, I guess the one thing, I think the major thing, two things that changed in the LP rule. One was they raised the threshold pretty significantly for transactions. So it's, I think now only going to cover 7 big tech companies rather than 17 or 18. And then they also changed some things so that it's not going to cover cryptocurrency. Those seem like the main changes. But to Marcy's larger point, I think it speaks to their philosophy of putting everything out there before January 20th. So before we get into the specifics of the various rules on the agenda and the guidance and what might change and what might not, I just wanted to talk a bit about how the process would run for making those changes, because it's more complicated and cumbersome than one might expect. This kind of goes to some of the larger themes I was alluding to earlier. So CFPB legislative rules, so rules that go through notice and comment, they can't be revoked by the stroke of a pen. Rather, under the Administrative Procedures Act, they have to go through another rulemaking process in order to revoke the final rule of the prior process. Now, this is different, as we'll talk about later, from the guidance, interpretive rules, advisory opinions, circulars. All of that can be quickly and easily changed and reversed. But for changes in approach on a legislative rule, the agency has to initiate a new process, and further, they have to acknowledge and explain their reasoning for why the agency is reconsidering those policy choices in the final rule. And this goes to Supreme Court precedent under the APA, the FCC versus Fox Television case from 2009. And it goes to the questions of whether agency action is arbitrary and capricious under the APA. And just to quote or paraphrase, some of that opinion, the agency need not always provide a more detailed justification than what would suffice for a new policy created on a blank slate, but sometimes it must explain when the new policy rests on factual findings that contradict those that underlay the prior policy, or where there's been serious reliance interests. So the payday rule, which we've talked about a bit ad nauseum here, but again, I think that's the number one precedent for how all of this is going to potentially go down in terms of final rules that are issued, either were issued previously or going to be issued in the next 2 months. And to try to summarize in about a minute a crazy quilt of procedural steps over many years, basically what happened was the rulemaking took 5 years, 2012 to 2017. As noted, it had two big portions: an ability to repay and a payment collection representment limit provision. So the rule was finalized in late 2017. Trade associations sued the Bureau to stop the rulemaking. And once there was a transition from Cordray to McMulvaney, the CFPB announced that they were reconsidering the payday rulemaking. They publicly announced that, and then in the litigation, they, I believe, filed joint motions with the challengers saying, we are going to be doing a new rulemaking. Let's apply for a stay, and the court granted it. So basically, the litigation was put on hold for a few years while the CFPB went through the rulemaking process of revoking part of the 2017 rule. And in 2020, the Bureau issued a final rule that revoked the underwriting requirements under the 2017 rule. And now, of course, that final rule went through notice and comment. So there were a lot of, the same collections of stakeholders that were very much supportive of the 2017 rule were largely opposed to the revocation, and vice versa. And then once that happened, the litigation kind of turned back on in 2021, and then ended up going all the way through the Fifth Circuit up to the Supreme Court, and now it's back in the Fifth Circuit. So this might be an outlier. I sincerely hope that whatever process occurs based on the current agenda doesn't take another 6 or 7 years to resolve. I don't think that's in anyone's interest in terms of finality and certainty. But in terms of a roadmap for how this would happen, the CFPB will let new leadership will come in. They'll evaluate everything on the rulemaking agenda, what's been finalized, what's still in the pipeline, and they'll have to make decisions one by one as to how to proceed. And that might also involve, questions about whether they're going to continue to defend against lawsuits challenging some of those rules. So let's talk more specifically about those rules, and I'll turn this one over to Chris.
Thank you so much, Mike. So the first one I want to talk about, and one of the ones that, at least from my perspective, is the most interesting in regards to what's going to happen next, is the open banking rule under Dodd-Frank Section 1033. So, in my mind, there are a few things to keep in mind regarding what might actually happen with the open banking rule. And I think the first and foremost facet of this, at least from my perspective, is it seems to me that open banking is really something that consumers want, right? They want the ability to more seamlessly move financial information from institution to institution, to change service providers. The idea that a consumer owns her or his own data is one that is enormously popular, right? So that's kind of thing number one when I think about what might happen to this. Thing number two, and it's kind of related, and that is that there are jurisdictions out there that do open banking a whole lot better than we do in America, right? Here, we do have some form of open banking, but it's primarily, through screen scraping and other I don't want to say obsolete methods, but lower tech methods that have lots of problems. Whereas in Europe, open banking has effectively been centralized, and it is governed, and there is a fairly straightforward way through which institutions and consumers can move their financial data from place to place. Third, and I think this is going to be a kind of a theme here as we talk about some of these rules that have gone final. 1033 is statutory, right? There is a congressional mandate to act. And frankly, if it is not ultimately enacted, there has been a willingness shown by lots of different trade groups. Again, something we'll talk about when we get to 1071. But trade groups have shown a willingness to sue the CFPB to force enactment of those rules. And then finally, and this could be one of the more important factors, but industry really has not been, the industry reaction has not been uniformly negative, right? It's been mixed, with a tempered to positive support from fintech trade groups and data aggregators, and then criticism from depository institutions and trade groups. So you do see some positive to mixed to positive reaction. Now the rule's being challenged by a Kentucky bank and 2 trade associations, so we'll see what happens in that litigation. But there are staged compliance states. So we're moving forward here, and as Mike mentioned, it's not as easy as clicking a button to make this rule go away. So with that, I'm going to move on to the next rule, which Mike will talk about with regard to overdraft fees and NSF fees.
Yeah, thanks, Chris. So the CFPB has 2 rules where they related to deposits that they issued a proposal on earlier this year. I worked on the NSF fee proposal as my final project at the agency. Basically, the overdraft rulemaking proposal would revoke an exemption under TILA and Regulation Z that allows the charging of an overdraft fee to not be considered a finance charge unless it's below a certain price point, a break-even point as they call it. And the NSF fee proposal is a UDAP rule that would prohibit debit card or certain peer-to-peer or ATM transactions where there's an NSF fee charged when the transaction is instantaneously declined. That's not a practice that occurs in the market today. It's more of a prophylactic rule that also addresses certain doctrinal issues related to abusiveness authority. So both of these rules were pretty heavily criticized by industry stakeholders, particularly the overdraft rule. So, again, based on what Marcy was alluding to earlier, everything we've heard from sources at the agency and chatter in DC is that they are going to move to release the final rules and allow the process to play out, and this could take different forms. I think particularly the overdraft rule would be vulnerable to a CRA challenge, given the heightened interest of the banking and other depository institution trade groups and stakeholders. Or the new administration could decide to, if there is a lawsuit, and I would expect there to be, to go through the process of deciding whether to reconsider the rule. So that's the situation on overdraft and NSF.
One thought, and maybe this is just something to ponder, right? It's like there's been such a focus on quote unquote junk fees, right? Has there been a significant impact on the market already? Has the Rohit Chopra already achieved what he set out to achieve? There are certainly financial institutions and lenders that have changed their practice in response to things like this, right? And I think it'll be interesting to see what happens, even if things do not move forward or things are CRA, how significantly the market has already been affected.
Yeah, I think they call that moving the Overton window, correct? And we'll see. And that's one point. And I know we're skipping ahead a little bit here, but one point I want to make sure we talk about before we get finish the deck is the Trump administration itself, and in particular the Trump campaign's kind of unusual or at least surprising focus on certain populist issues, right? And one thing I wanted to mention that I think is very interesting is that Trump had this promise to cap credit card fees at 10%, right? That is not a typical Republican side position to take by any means. And you've seen this over the last week and a half, right? Bernie Sanders, I think it was last Friday, came out and said, look, if Donald Trump wants to cap credit card fees at 10%, I'm all in. Let's do this. And then yesterday, Elizabeth Warren posted on Twitter or X or whatever you want to call it, I'm in too. Let's do this. Let's cap credit card fees at 10%. Right. And then I've followed a lot of political kind of prognosticators looking at why was it that Trump won when a lot of folks didn't think he would. And I think that part of that is this kind of idea that there is a populist push in this country, right? That an anti-establishment, anti-big business, populist kind of a milieu in which Trump utilized some of that feeling to propel him back to office. And this 10% promise was part of that effort. Now, the question is, will he follow through on that, right? Now, do I think that he will follow through on capping credit card fees at 10%? Almost certainly not, right? Because frankly, I don't think consumers would like that, given that very few, if no credit card issuers are going to enter a market where interest rates are capped at 10%. But are there other maybe less existential rules that might actually become a little more sticky in light of some of that populist feeling? So food for thought, right? Certainly that could raise its head in 1033, where there is a lot of popular desire for some of these solutions, but also the late fee rule, where credit cards are going to be capped at 8%, right? That's still a pretty radical rule, but it's certainly not as radical as a 10% interest cap. So we'll see. I do want to quickly talk about 1071 because I do think this is interesting as well. 1071 is HMDA for small business lending, a rule requiring that small business finance companies collect and report data. And unlike 1033, 1071 has not been well received by industry participants. And I think in part there's a cultural issue at play here, right? And I think it comes from three areas. First of all, commercial lenders and finance companies are not used to consumer style regulations, right? I work with a lot of commercial lenders and factors and alternative small business finance companies, and they're not used to being regulated, right? And then second, and relatedly, this is a hard regulation to comply with. It is not a training wheels regulation, right? Compliance costs are really high. The CFPB had estimated that one-time costs were going to be around $44,000 to $78,000. The American Bankers Association said, no. When you actually look at this, the one-time cost is going to be anywhere from $112,000 to $7.5 million, depending on how many finance originations you offer. I think that's closer to the right amount. And then in terms of ongoing compliance costs, CFPB estimated $8,000 to $278,000 in ongoing costs. ABA said it's more like $72,000 to $2 million per year. So that's the second reason that folks don't like it. The third reason is that 1071 is a substantial risk multiplier. That type of data that is going to be reported it's critical for ECOA disparate impact claims. It's hard to make an ECOA disparate impact claim without the type of data that 1071 is going to make available. And it's going to make it a whole lot easier for state and federal regulators and the DOJ and private litigants to bring claims, and for the media to run with headlines about purportedly discriminatory acts and practices by commercial finance companies. So folks don't really like it. That being said, that keep in mind that the 1071 rulemaking was launched under the Kraninger CFPB, largely as a result of litigation initiated by the California Reinvestment Coalition and other trade groups. That litigation was launched back in 2019. They sued the CFPB claiming APA violations. Now, the plaintiffs ultimately filed a stipulation of dismissal with prejudice back in April of 2023 when the final rule was issued. So if the CFPB does attempt to pull it back, though, it was filed with prejudice, but there would be new facts if the CFPB tries to pull it back, and there could be a new lawsuit. Now, I could see, given some of the breadth of the 1071 rule and some of the problems with the 1071 rule, I do see the CFPB maybe expending some capital to maybe tweak some things here. So we'll see what happens. Marcy, I'll let you talk about that.
Yeah, thanks, Chris. Also, just a note on 1071. During the Kraninger administration, we did not see a pullback on fair lending focus, right? And in fact, the Townstone lawsuit was filed under Kraninger. And as many of us know on this call, the decision from the Seventh Circuit upheld the expansive meaning of applicant to include prospective applicant and apply during the marketing phase of a consumer credit life cycle. So I think, right, could we draw some lessons from that? And 1071 is based on ECOA. So
yeah, and I think it's going to come down to what Mike was talking about earlier, which is to say it could very well depend on who in fact sits in that chair. You know, if it's someone like Kraninger, maybe we don't see a pullback, but if it's someone who's a little more aggressive, we might not. It's all about who's going to be there.
Just to add to Chris what you were saying, I think it's also very instructive here. You made the point about how the consumer advocacy lawsuit was what kind of generated the push to move forward on 1071. I think again we're trying to like dispel misnomers in part in this presentation, and one of the misnomers is that again, to the earlier point of like expect the unexpected, or is that the lawsuit, the dynamic of agency position reaction with the lawsuit, that cuts both ways on both sides of the equation. So to add to the crazy quilt of the payday story from earlier, is that one detail I left out is that when the CFPB issued the rule in 2020 to revoke the underwriting requirements, they were then hit by a lawsuit from Public Citizen and other advocacy groups challenging that rule under the APA, saying that the administrative record was insufficient because we had this 1,000-page administrative record from the rule I worked on in 2017, and how could they just revoke it? That ended up being dismissed, I believe, for lack of standing, and the Biden administration made the decision to not actually reopen that rulemaking. All this like makes my brain hurt, and like I was on the inside for so long, I'm sure it makes all of your brains hurt. But the larger point here is we're going to go through this list and say, well, we think there's a lawsuit, maybe the CFPB will change its position, that makes it likely that the rule will get revoked or whatever. Don't sleep on the fact that anytime that happens, you could then get a lawsuit from blue state attorney generals, consumer advocacy groups filed in the DC circuit or the other circuits friendlier to Democrat or progressive interests that challenge the new CFPB's actions. And so it might just be this ping pong effect. And again, it just adds to the uncertainty and the unpredictability of how this is going to play out.
I mean, are we even America if we're not talking about lawsuits? No. All right.
Would say.
All right. What else could be on the chopping block? So the CFPB announced some potential changes to FCRA and finalized or issued a proposal to prohibit medical debt reporting, which was one aspect of its announcement on changes to FCRA. The other aspect, which it relates to data brokers, there has been no rule that has been proposed. So on the medical debt rulemaking, right now, currently a proposed rule, there's a lawsuit out there by ACA International, and question whether the CFPB will move full steam ahead on finalizing that rule. Again, what we've heard on the ground is yes, the CFPB is going to continue and press forward. On the FCRA, on the data broker part, the CFPB has been working to release a separate notice of proposed rulemaking to subject data brokers to coverage under FCRA. Again, that's a pretty big misnomer, right? If we're going to abolish those, if indeed what the CFPB has telegraphed it wants to do with respect to data brokers under FCRA, it would be very impactful across the market. It would consider credit header data that is used in identity theft tools, in marketing, to be considered a consumer report, which for a long time, even under case law, credit header data has not been considered to be consumer report information. our belief is that this would be dead on arrival under new leadership, which should really be a big relief for the market and the industry. All right, what else could be on the chopping block? I'm going to pass this over, I think, to Mike, right?
Yes, and I do want to acknowledge that we're at 2 o'clock. I think we had intended to get this under an hour, but we're falling woefully short of that aspiration. So obviously, if some of you have to drop, feel free. The recording will capture everything, and those of you that want to stay on, we'll do our best to move through the rest expeditiously. So one of the ones we wanted to highlight was the mortgage closing cost rulemaking. Marcy was alluding earlier to this general theme of attacking so-called junk fees. This has been a pretty pejorative phrase, term, by industry, in the view of industry stakeholders. In my view, it's sort of become a bit of a political branding exercise across the Biden administration at large. There have been a lot of rulemakings across different agencies, from the FTC to the Department of Transportation and to the CFPB. The idea of a non-competitive fee or a fee that is, the front end costs are hidden and it's only disclosed on the back end. That has sort of become, this much larger exercise where, as some people joke, like, anything is a junk fee. It's way beyond, Ticketmaster processing charges or whatever. But so the CFPB kind of delved into this realm related to mortgages for the first time, because it really has been focused on non-mortgage areas, and they foreshadowed this approach in a blog post earlier this year and then an RFI, where they talked about credit reporting fees, title insurance fees, where the lender's title insurance that the borrower pays, and then mortgage discount points. And they focused on these 3 areas and signaled that they had great concern and that they weren't subject to competitive forces. And, kind of reading the tea leaves of the RFI, the request for information, and the blog post, it really seemed to me that the Bureau was going to be entertaining a theory related to abusiveness, UDAP abusiveness, and particularly the inability to protect interest, the idea that some of these fees are they're the product of structural forces in the market or market concentration, particularly when you're talking about credit report fees. The director, Chopra, has been sort of incessantly talking about this issue. Even yesterday at a AI conference sponsored by a nonprofit in DC, he gave remarks, and most of his remarks were not talking about AI, but they were rather talking about credit reporting and the fact that there are, in his view, non-competitive forces. And he was talking about the possibility of developing an AI open source tool that would be a rival to FICO. Very interesting sort of aspirational policy goal. But the point is that this is an area where both the policy and where they are in the process, I think, indicates that this is going to be DOA, because this is in an earlier phase than the other rules we've been talking about. They haven't issued a proposal yet. They've just issued a request for information. They haven't gone through the small business review process, which, as you all know, is a necessary step for major rulemakings. So given the unpopularity across industry of the junk fee initiative, quote unquote, I do, notwithstanding the earlier interesting part of this discussion where, Chris, you were making the point about the populism strain and credit card late fees. I do think that on mortgage closing costs, in my view, I think it's unlikely that they would move forward. But I guess never say never. So then Marcy will talk about the 2 of the rules related to non-bank registry.
So a couple of years ago, the CFPB telegraphed that it wanted to promulgate rules requiring non-banks to register certain terms and conditions, namely arbitration agreements, and also telegraphed that it wanted to create an enforceable orders or an orders registry. The CFPB has achieved one of those proposals. It finalized a rule to stand up a CFPB non-bank registry that once it is effective will be published for all to see. The covered non-bank enforcement registry would subject any covered non-bank, not just supervised non-banks, to the rule. And would require a non-bank to file with the CFPB when it is subject to covered orders. Covered orders is incredibly broad. It includes a various set of statutes that have allegedly been violated. It would include it does include federal consumer finance laws, other laws that the CFPB may enforce, Section 5 of the FTC Act, so UDAP, and then also a huge appendix of state UDAP laws. So broad. And one huge sticking point on this rule is that for supervised entities, they subject to a covered order, they would on an annual basis have to prepare and submit a signed attestation of the supervised entity's compliance with each covered order. So it would be the highest ranking senior executive officer overseeing compliance with that federal law and the covered orders. And the CFPB would publish that name and the title, but not the attestation. So to the extent a non-bank is subject to this registry and these requirements, it's a pretty big deal. We haven't seen the terms and conditions rule proposed yet. But regardless, we think that if there is a proposal, the terms and conditions proposal would likely be scrapped by the new administration. Question what the CFPB in a new administration might do on the enforcement registry, of course, harkening back to what Mike said, it's not as easy as a stroke of the pen to eliminate that. And I don't think we're at all in the 60 days of a continuous session for a CRA on that one. All right.
Yeah. So briefly talk a little bit about the credit card late fee rule, which is another one that we think, notwithstanding my statement earlier about the surge of populism, I think it is more likely than not that this rule is also on the chopping block. Now, typically a credit card late fee is going to be $32, but this rule effectively lowers the cap to $8. The rule itself was released in March of this year, and but litigation was filed in the Northern District of Texas. And, I think this is the one that was initially interesting because Judge Pittman kept trying to get it out of his courtroom on venue grounds, and the Fifth Circuit kept saying, no, it's going back to you, Judge Pittman. So finally he threw up his hands and said, well, it's going to stay here, so I'm going to issue an injunction. So currently the rule is enjoined, but there are likely two avenues where we could see this going if it is pulled back. Obviously, one is that the CFPB would change its position in the litigation, or it could go through the process that Mike spoke about earlier, where the Bureau effectively kills the rule. So finally, we're going to talk about some of the non-rulemaking guidance, and one of the kind of biggest kind of signatures of CFPB Director Chopra's tenure has been this use of non-rulemaking guidance and circulars and a revitalized innovation office. So first, I'm going to talk about the CFPB and their non-rulemaking guidance, and as I mentioned, this iteration, the Chopra version of the CFPB has been extremely active about using circulars and consumer advisories and other types of reports to highlight issues that it sees as important or to provide interpretive guidance to the industry. Few examples, right? Issue spotlight on junk fees, the circular regarding broad non-disclosure agreements that could be used to deter whistleblowers, the UDAP in the solar panel space, tons of different blog posts, and one fireside chat where a CFPB director called consumer financial services lawyers leeches. Now, the problem with this comment, in which he stated that lawyers who challenge these non-rulemaking guidances and the Bureau's interpretations, and then he pointed out that when we point out the ambiguous nature of the Bureau statements, he said that we were doing this so that we could boost our billable hours. But the problem, I think, with Director Chopra's argument here is that that very use of non-rulemaking guidance doesn't really always add clarity. And in addition, the guidance has limited applicability due to its fundamental limited force of law. So taken together, it's really not clear how the industry should be able to rely on this guidance, right? How much weight should a member of the industry put on the guidance? We don't know how far the extent of the power of the Bureau should apply when these types of guidance are released, right? So you have oftentimes ambiguous statements with limited force of law that really provide the industry limited reliance interest, right? So it's this lack of certainty rather than lawyers just practicing law that creates these issues that I think Director Chopra was pointing out, But what does the industry appreciate, right? Consumers and the industry benefit from clear and consistent legislative rules that are issued through formal rulemaking where all stakeholders have the opportunity to provide input, right? And I think that really for the last, since the CFPB has been around, it's been a fairly straightforward position from the industry that if you're going to govern us, give us straightforward rules, and rather than non-rulemaking guidance and circulars and fireside chat where there's a lot of ambiguity. And I do think that it's likely that the new CFPB will pull back on this heavy reliance on non-rulemaking guidance. And I think we can all agree we're looking forward to that and having a greater level of certainty, hopefully, in the space. Because I do think that it's not that the industry doesn't want to be governed. I think everyone understands the value of governance and regulation. It's that we want to understand what are we supposed to do. Marcy, I'll let you pontificate.
Yeah. And here are a few that,
you don't mind if I interject? And Chris, you made the best defense of leeches that I've ever heard. We should brand your last 5 minutes in defense of leeches. In all seriousness, I mean, the rhetoric has been interesting. I would say. I think there was an earlier time when he referred to it as vultures circling. So what was the thought process from vultures to leeches? Maybe in a sense it's an improvement because leeches used to be used for medicinal purposes. So maybe there's some acknowledgement there. Yeah, and and we've I think done some writing or speaking on this subject before, but just as someone who wrote some of these guidance documents, like the RESP advisory opinion in 2023, I firmly believe there's a time and place for guidance. And in fact, in 2018, the Bureau under Mulvaney, did a broad request for information, asking for feedback on basically all of the existing rules, the new ones that we wrote, and then the existing rules that we interpreted. And a lot of the feedback from even from sectors of industry was, give us more guidance, because a lot of things were unclear, particularly issues like RESP Section 8, which is clear as mud, as those of you who practice in that area know. The problem is that this barrage or explosion of guidance, the volume is really tough, which is on your position, but it's also that it doesn't seem like it's tailored, and it doesn't always seem like it's really responding to the areas where the guidance is being called for. And frankly, in some cases, it seems like it's being used as an expedient substitute for notice and rulemaking, notice and comment rulemaking, as for example, in the buy now, pay later interpretive rule, there's a lawsuit pending. So the Bureau also tends recently to conflate, Marcy and Chris, and probably some of you have heard this riff before. I mean, they conflate the significance and authoritativeness of different vehicles under the APA. Some of them are more formal, some of them are less formal. But every press release accompanying these documents kind of reads the same way. CFPB takes action to stop X, Y, or Z, but that particular action has different legal significance. So that's why I think, I mean, if you're sensing a bit of, maybe black comedy defensiveness here, in defensive reaches, I think it's born of this, constructive critique of, that Chris articulated very well. Sorry, I interrupted you.
Yeah, no. I mean, I think that, and I would, a cynical view, and I'm not cynical, but a cynical view would be that, Chopra was not intending to give actual guidance, right? He wanted to impact market. And so that's what he's done, right? He took a broad brush and has impacted markets in a way that he thought they should be impacted, as opposed to, I think, your point, Mike, where it's not receiving and understanding particular operations or particular problems to solve. So these are some of the non-rulemaking guidance that we think might be revoked under a new administration. And again, question whether any of these, it would be better served to have them CRA so that they don't show up again in a future administration. My friend Mike on this call, he helped write the first abusiveness policy statement in 2020, right? And then that was revoked by the current administration and replaced with the very long and hateful on profit policy statements. All right, I think back to you, Mike.
Yeah, just to pick up on that last point, I mean, I want to just present a bit of like the slight counterpoint here, or at least they likely will revoke all of this guidance, and I think that will correct perhaps some of the overreach. The question then is what happens next. I mean, it's not good for durability and for policy certainty to have this whiplash ping pong approach where, as Marcy alluded to, I literally engaged in like the high school policy debate exercise of helping write a policy statement on abusiveness under Director Kraninger, and then turning around and helping write the policy statement under Chopra on the same subject. So I mean, it was an interesting exercise as a lawyer, but I think for all of you who have to absorb and figure out how and if to how and when to comply, that doesn't create that type of smooth glide path. So I do hope that if and when the CFPB new leadership kind of wants to go through the list of the guidance, that they're discerning about it, and that they recognize that the continuation of this cycle may not be best for everyone, including for industry. But just to talk about innovation, if you all recall, in 2019, Director Kraninger stood up an Office of Innovation at the Bureau, and they were basically open for business to grant different types of regulatory relief. They had no action letters, trial disclosure waivers, compliance sandbox approvals, and I was involved in this activity as a subject matter expert. We were getting a lot of, in particular, RESPA Section 8 interest in no action letters, and we helped develop a no action letter that was issued to HUD on behalf of housing counseling agencies as a way of incentivizing lender funding of housing counseling. I think everybody kind of viewed that as a win from like a policy perspective. But this office was very empowered. They had a structured process developed to engage with fintech companies and more established companies who were interested in developing new platforms, new products, where perhaps there was regulatory ambiguity, or there wasn't really a playbook in terms of how to navigate the regs that were under the CFPB's purview. And so, in my, humble opinion, I thought this was a very welcome policy change by Director Kraninger. I was enthusiastic, as a participant in that process from inside the agency. The current leadership went in a very different direction, and they wound down those policies for the most part. They moved the Office of Innovation down in the org chart. They used to report directly to the director. They were moved under RMR, and they were repurposed as the Office of Competition and Innovation, really tasked with more of a market intelligence and market monitoring function. And, a lot of the people that were at the agency in the Office of Innovation in 2018, 2019, they're still there, working under this new function. And I do think, given all of the activity in this space, all of the questions about AI and the intersection of regulation and technology, banking as a service issues, which largely fall under purview of prudential regulators and third-party risk management, but there are intersections with the CFPB. And for example, there was a request for information put out by the Treasury Department earlier this year, asking a lot of really good questions about the use of AI in financial services and trying to ascertain where are the challenges and where are the opportunities, and are there regulatory or legislative fixes that could be useful towards paving the way to mitigate those risks and enhance those opportunities. And the CFPB largely has been on the sidelines. They filed a comment letter that was very critical of AI, that really just talked about the risks and not the opportunities. And they've given some speeches. They didn't use the word leech, but they called fintech founders basically bad faith actors. So the rhetoric has been pretty harsh. I do think, and maybe it's wish casting, because again, I'm pretty upfront that I really believe firmly in what the policy was before, that they will likely bring back this type of function. And again, this is in part, this is one of those healthy philosophical debates that I mentioned at the beginning, where the Kraninger, view was innovation is facilitated by engaging with stakeholders individually and giving them pathways towards reducing the ambiguity and getting regulatory relief through that direct engagement. Whereas Chopra had a very different view. They thought that type of approach was favoring those who had access, and they thought that the way to do it was to issue guidance more broadly. So I do think that this is an area where you're going to see a change, and in my view, a welcome change. We have a poll question. I'm very, very grateful that we still have looks like 148 people listening to us. Which CFPB non-rulemaking guidance should be rescinded on day one of the new administration? The BNPL interpretive rule, the 2023 abusiveness policy statements, or all of it? I think I know which one is going to get the most votes, but we'll see what happens. While you're voting, so a couple of questions in the chat that we could just quickly address. One person asked, what if anything is likely to happen to pending CFPB enforcement actions? We are going to get to that in 1 minute, if you'll stay with us. And then another was more of a comment. Perhaps the circulars, quote, are intended as ammunition for class action lawsuits. Maybe these are the good lawyers, not the leeches. That's a good comment. Just on the circular point, I think the CFPB has been very upfront, even if you read the boilerplate language in every one of those circular documents, that they are intending the audience for the circulars to actually be other regulators. So it may be, residually or kind of intentionally behind the scenes, for class action, but I do think they're largely aimed at, the federal prudential regulators and state regulators as a way of the CFPB nudging them. Say, here's our view. We would love it if you aligned with our view as well. And it's also worth noting, and this came up in some of the conferences this week as well here in DC, that under the current administration, they've been engaging in essentially taking positions on state legislative and regulatory issues much more than in the past. They filed a letter, for example, in New York when they wwere considering a change to their statute to include an unfair and abusive prohibition at the state level. And they engaged in California's process related to earned wage access. And this is definitely something that has been notable. A lot of people in the industry have been talking about it, the fact that they were really trying to put their thumb on a scale in a way that they haven't before. So that's also something that you may see a change going forward. So in terms of the poll, okay, so 60% thought all of it, so maybe 40% thinks it should be a discerning type of approach. So let's go to enforcement and supervision to address one of those chat questions.
Fantastic. And I think my favorite question here, or at least comment in the Q&A, is from a gentleman who asked, won't the lawyers get Dick the Butchered from Shakespeare's Henry the Sixth, which I think is the quote, right? First, we kill all the lawyers. So very well could happen. Gotta have eyes in the back of your head. So that being said, let's talk about enforcement. And I think there's been a lot of excitement after the Trump victory that enforcement might slow down. If we're going by, if past is prologue, I think it might be maybe unwise to at least kind of rely on that, right? There might be an initial period of evaluation by new leadership of the pending docket, because that's kind of what happened in 2018. But and then, the docket now might look kind of artificially low because a lot of cases are on hold pending resolution of the CFSA case. So there's kind of a ramp up there. But when you look at the the first Trump administration, some of the biggest CFPB consent orders occurred under the Mulvaney and Kraninger CFPB, right? And then as Mike mentioned earlier, it's almost certain that state regulators and some of the states that are more kind of consumer friendly will step up and bring more aggressive oversight. We have seen that in the past, and we could certainly see it again. But one thing that I do think, when I look at kind of under the hood to determine what was the real difference between enforcement under the Trump era CFPB and the current CFPB. And I think during the Trump era CFPB, you saw enforcement actions, or at least efforts, go towards kind of practices that went a little bit beyond just technical violations, right? Violations that were truly problematic, acts and practices that were really, when you dug into the facts, issues that I think kind of uncontroversial, that something should have been done to stop those acts or practices. Whereas, during the Chopra CFPB and I guess the Biden era CFPB, our concern has been not just kind of those acts and practices that could be seen by anybody as really problematic, but also technical violations, right? Ticky-tack actions and claims. So I think that the tenor will change, but the broad kind of consent orders, or the amounts at issue in the consent orders, that might not be a whole lot different. But the other thing to keep in mind is this, and that is that you should not underestimate the fickle nature of the American public, right? The American public is notoriously difficult to predict, right? And we see large swings in public opinion and swings in who wins elections. We've just seen that, almost on a yearly basis. And what happens if in 4 years the Democrat wins, right? And there's a large reaction against the Trump administration, or the second Trump administration. Well, there is a look back period, right? Things that maybe occur in 2025, 26, 27, 28 could be actionable by a future CFPB. They will look back and say, okay, just because you had the Trump administration and maybe a less aggressive CFPB does not mean we will go back. We will not go back and take action against things that happened then. So, don't get too excited about your ability to maybe push the envelope, too much, because you might have a CFPB in 4 years that is radically different. And go ahead, Marcy.
Chris, your comment on technical violations resulting in enforcement. There was a recent credit union consent order, which those don't happen very often, where the credit union proactively sought to make members whole. And nevertheless, CFPB issued a very harsh consent order. And that is often a question we get asked by clients, right? Well, I'm taking these proactive measures to reduce or eliminate consumer harm. Will that matter, right? And that consent order, you reading between the lines, the answer would be no. You still are going to appear in the headlines at least under the Rohit Chopra administration. The other thing to note, I'm curious if the repeat offender unit will be eliminated, right? And that is a scary unit, right? Because you don't want to be considered a repeat offender, especially given these like technical violations that are often aggrandized into these harsh consent orders.
That's a great point, Marcy. My sense is that the repeat offender notion is really Chopra. That's like something personal, like it dates back to when he was at the FTC, and he was very critical of some of the settlements, like the Facebook settlement, and I think so that may be reflective of a policy shift if you see a move away from that.
Yeah, I think that would be a welcome relief. So what will happen to supervision? It's difficult to predict. With respect to Kraninger, she emphasized prevention of harm via supervision, and so we may see a return to this. I want to focus a little bit on the new stuff, the CFPB's dormant authority. That is authority that comes straight from the Dodd-Frank Act. And under the dormant authority provision, if the Bureau has reasonable cause to determine by order after notice to a covered person and a reasonable opportunity for that covered person to respond, determines that the conduct in which that covered person is engaging poses risk to consumers, then the CFPB has the authority to designate that entity as a supervised entity. That's separate and apart from the statutory authority of supervision that the CFPB has and the larger participant authority to designate companies as larger participants and become subject to the CFPB's supervisory authority. Under the prior administrations, until Chopra, this authority was largely not used. Once Chopra took over, he used it pretty aggressively. And in fact, it was basically threatened that if you got such a request to agree to become a supervised entity and you objected to it or contested it, that would, and then you lost in that endeavor, it would become public. And that indeed happened with one particular lender. So people considered this to be a name and shame game. We anticipate that the CFPB is going to relax its use of this dormant authority. All right, other implications to discuss. Mike, I think this is you.
Yeah, and just a brief addendum to what you said about the dormant authority. At the very least, I think we'd expect them to potentially change the procedural rule that allowed for them to publicly disclose the designation or the outcome of the designation proceeding. That was a change that kind of paved the way for the name and shame, as you put it, Marcy. Whether or not they actually, behind the scenes, do initiate those proceedings. Obviously, if you don't have the possibility of only the CFPB, speaking publicly about it, because the entities can't speak publicly about it because it's considered confidential supervisory information, then that kind of changes the negotiating dynamic among the parties. So we may see that at a minimum. but just, yeah, we appreciate your patience. There's a lot of material here. Hopefully this has been informative and insightful. Just a few sort of loose ends here. So one is that, now that the control of Congress has been decided, I think last week, I believe, it was clear that the Republicans were going to retain the House, although it's a very, very slim majority. It's possible there could be legislative efforts to change the structure and the funding mechanism. This is something that is, in every Congress, there's usually a bill introduced by Republicans to either put the CFPB on appropriations or change it to a commission structure. I think we would expect there to be efforts in that vein. It does seem like, though, unless the filibuster was dropped, that those efforts would fail, even with Republicans retaining control. There may be other things, though. I mean, we mentioned the GS salary scale. There could be efforts either through OMB actions or executive orders to try to put the CFPB on more of the general pay scale rather than the specific higher pay scale that they're on currently. There also could be issues like trying to bring everybody back to the office full time rather than allow for remote work. Did want to touch on kind of the broader picture about the DOGE, the Department of Governmental Efficiency. And you may have read the op-ed this week in the Wall Street Journal by Elon Musk and Vivek Ramaswamy, detailing their pretty grandiose visions for how that's going to work. And obviously that's something that is kind of in the background here. If those efforts get traction as a political and a legal matter, then they potentially could radically affect the CFPB along with many other agencies. There are also, some of you may be familiar with the idea of Schedule F. There was an attempt under the first Trump administration towards the end to reclassify many of the federal employees in the federal workforce to a different employee classification where they could be subject to less protections under civil service laws. If there's a revived effort, and I think people here expect there would be, given that Trump is going to be nominating the same individual, Russ Blatt, who ran the OMB under the first administration. That's something I know just from speaking with former colleagues, that there is some sort of inchoate, in a sense, nervousness about the possibility of people being reclassified and then losing those protections. So again, I mean, do they want to break things or do they want to fix things? That's what I keep going back to in terms of we just don't really know. And then lastly, again, there may be an opportunity to reset the staff relationship and do more institution building. But if Schedule F happens or DOGE gets traction, then that obviously will be going in a different direction. So I believe we are finally through everything. And again, we really appreciate those of you who are still, there's only a couple of people still on, but those of you who will probably watch the recording, thank you for joining us. These are important developments, and we are available to be resources, sounding boards, to get into any or all of these issues as they come up during the next few months as you navigate the transition and all of the impacts.
Just a couple housekeeping items. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete our short survey. We use your feedback to make sure we can plan future programs that are applicable to your business needs. This concludes our webinar. Thanks so much, Mike and Chris, for joining me today. And thanks to you all who stuck with us and who are watching this recording. Have a great day.
Thank you.